Hello all, welcome back to CMA Vamsisa official channel. Today I am going to give the classes regarding the Companies Act of 2013, and today I am going to cover 1.1 company formation and conversion. This 1.1 full activity I am going to teach you. It covers entirely 33 pages. So open your law textbooks and keep in front of you. I am going to read the line by line and give the explanation in detail. I will try to attach the practical real-time knowledge examples outside there in the market. So let's see. Let's start the video.
So the Companies Act 2013 SLOB mapped against the module to obtain in-depth knowledge of various provisions of Companies Act and rules that govern the operation of a company at each and every stage. Students have to obtain in-depth knowledge about the Companies Act and the rules that govern the operation of a company at each and every stage. To develop a clear understanding of rationale behind various provisions, particularly on accounts, audit, and dividends, and its effect on the company. And also they are expecting the student learn provisions relating to accounts, audit and dividends and its effects on the company. Okay. Module learning objectives. What are the objectives behind this module? So after studying this module, the students will be able to perform their job based on the understanding of the company law procedures, relate accounting job with other functions of the company, particular reporting functioning, aware of the portal provisions and shall be serious about their work to avoid non-compliances. So students will, after getting know about all details regarding the subject, they can concentrate on their job and they can see that the company adhere to the provisions and based on that provisions, the company should function. So without unfollowing the provisions, when a company functions, then the company will have chances to success. Next, first topic 1.1.1 incorporation of private companies, public companies, company limited by guarantee, and unlimited companies, and conversion or reconversion or re-registration. First introduction. Companies Act 1913 was the first structured law on the form of organization. Some of the concepts of 1913 Act are still present in 2013 Act. This Act continued till 1956 when the first Companies Act 2 of independent India was passed in 1956. So at the beginning, the Companies Act was 1913 and it continued until 1956. Even in the recent Companies Act of 2013, some of the Companies Act rules related to 1913 are still continuing. And this act has regulated most eventful years of growth and a stabilization of corporate India government, and made many attempts to introduce a new Companies Act, and various committees were set up. Replacing an act of such large magnitude was not small task, and many facets were to be seen. After 57 years, the new companies were drafted and passed in 2013. Currently, we are in our existing society. Companies Act 2013 is followed by every company. So from 1913 to 2013 or 2024, after 57 years, they were made so many changes for the Companies Act. So many meetings were kept. So many committees were held. So based on the constant changing in the environment or constant changing in the society, so many new laws and new rules were introduced for this Companies Act, and currently we are studying Companies Act 2013 with all the amended rules. Next, the Companies Act 2013 consisting of 29 chapters, 470 sections and 7 schedules as against 658 sections and 13 parts and 15 schedules in Companies Act 1956. So in recent Companies Act 2013, we have 29 chapters, 470 sections and 7 schedules. In 1956 Companies Act, we have 658 sections, 13 parts and 15 schedules. Next, was notified partially on 12th September 2013, 55 sections, and partially against on 26th March 2014, 168 sections with effect from 1/4/2014. Part of the provisions related to National Company Law Tribunal have been notified with effect from 1st June 2016. The Companies Act 2013, hereafter the Act, consolidates and amends the law relating to the companies in India and replaces the Companies Act 1956 in phases, so which is 56 years old. The new act intends to improve corporate governance and to further strengthen the regulations for the corporate sector. So, with the introduction of key provisions as to duties and liabilities of directors and independent directors, auditors, ration, establishment of serious fraud investigation office, constitutional of National Financial Reporting Authority, class action suit, corporate social responsibility. So, in the new Companies Act of 2013, what it contains means improve. So it tries to improve the corporate governance and to further strengthen the regulations for corporate sector with the introduction of key provision of duties and liabilities of director or independent directors. It contains a set of duties for both the directors and independent directors, and also auditors rotation, establishment of serious fraud investigation office, constitution of National Financial Reporting Authority. So all these topics are contained in the new Companies Act of 2013. Okay, next. The Companies Act of 2013 is administered by the central government through the Ministry of Corporate Affairs and the offices of Register of Companies, official liquidators, public trustee, director of inspection, National Company Law Tribunal, National Company Law Appellate Tribunal, etc. So, the Companies Act 2013 is administered by the central government through the Ministry of Corporate Affairs. Via MCA, the new Companies Act is introduced by the central government. Okay, and the offices of Register of Companies, official liquidators, public trustees, director of inspection, National Company Law Tribunal, National Company Law Appellate Tribunal. So these are also set up by the central government. The Register of Companies (ROC) controls the task of incorporation of new companies and the administration of running companies. ROC, what is the main focus or main duty of ROC means registration of companies and also the administration of running companies. So the Ministry of Corporate Affairs (MCA) was primarily concerned with the administration of Companies Act 2013 and other allied acts. So MCA mainly focuses on the administration of the Companies Act and other of its allied activities. Okay. So rules and regulations are framed thereunder mainly for regulating the functioning of the corporate sector in accordance with law. So MCA mainly focuses with the registration of companies and also the administration of the companies. So and also checks whether the company is functioning by following the corporate laws or not. So the structural shift is that while in 1956 Act only 16% was delegated to central government, in 2013 Act 74% is delegated legislation. So this has resulted to frequent changes in the rules. So earlier the structural shift in that while 1956 is only 16%, but in 2013 the structural shift is 74% is delegated legislation. So this percentage variation came is due to the resulted due to the frequent changes in the rules. The Act was amended in May 2015, 2017, modified in January 2018, July 2019, and September 2020. Relevant provisions of the amendments to the extent under syllabus have been incorporated in this study material. Okay. Next 1.1.2 definition and features of the company. So this Act says definition and features. What do you mean by company? So what are the main features of a company? So in order to call a company, what features it should have, like that. First we go for the definition. Company is an artificial, legal and juristic person separate from its member having perpetual existence. So company is nothing but an artificial person. Means it don't breathe, it don't die, it don't sleep, but it will exist. We will call it as a person, but it don't have any characteristics of a living organism, but we call it as a person in the eyes of law. So in terms of Companies Act 2013, company means a company incorporated under the Act or under the provisions of the Company Law, Section 2, Clause 20. Section 2, Clause 20, if a company is established under this section, we call it as a company under Companies Act 2013. So a company may be an incorporated company or a corporation or an unincorporated company. An incorporated company is a single and a legal artificial person distinct from the individuals constituting it, whereas an unincorporated company such as partnership is a mere collection or aggregation of individuals. So an incorporated company is a single and a legal person distinct from the individuals constituting it. So it is separate from individual. It is only having what is that an incorporated company is a single one, legal one. So whereas an unincorporated company such as partnership is a mere collection or aggregation of individuals. So group of combined people together is called as an unincorporated company. only one single entity or only one single person, legal person, is called as an incorporated company. Okay. Therefore, unlike a partnership, company is a corporate body and a legal person having status and personality distinct and separate from that of the members constituting it. Okay. Features of a company: independent corporate existence. What these are the features? So, if any company contains the following features, we should call it as a company under section 2+20 of the Companies Act 2013. So first feature, independent corporate existence. It must have independent corporate existence. What does it mean? The outstanding feature of a company is its independent corporate existence. It is distinct legal person existing independent of its members. So it is different from members. So member is different and the company is different. So members' existence is different from company's existence. So by incorporation under the Act, the company is vested with a corporate personality which is distinct from the members who compose it. So the members who compose it, the members who started the company, and both were are not the same. Members are different and the company is different. All well-known illustration of this principle is the decision of the House of Lord in Solomon versus Solomon and Company. Okay, and Co. So the case law representing this feature is House of Lords in Solomon versus Solomon. So in exam, if this question comes, describe the features of the company, like that. If you receive any question, means we can give the independent corporate existence. You can give these lines in the exam, and you should mention, quote the case law Solomon versus Solomon and Co. So what it explains means the company is different and the members who created the company are different. Whatever the liabilities that are applicable to the members does not apply to the company. The members' liability is different from the company's liability. Okay, that's what they are saying. Next one, limited liability. Next feature. So the privilege of limiting liability for business debts is one of the principal advantages of doing business under the corporate form of organization. So limited liability is one of the main advantage for doing the business via company format. Like why it is a benefit means where the subscribers exercise the choice of registering the company with the limited liability. The members' liability becomes limited or restricted to the nominal value of the shares taken by them or the amount guaranteed by them. So when a company starts by few members and they opt for the option of limited liability. For example, if the share value is 10 rupees means and the company liability is 100 rupees means, so the member have a share value of 10. So he will only bear the liability up to 10 rupees only. That is called limited liability. Beyond the 90 rupees is not related to him and it is not his responsibility. So if a company is formed with limited liability concept means whatever the company liability, but the liability will pertains to this particular member is only up to his share value. Okay. So no member is bound to contribute anything more than the nominal value of the shares held by him. In the normal course, a shareholder is liable to pay for the shares as and when it is called up by the company. In case of default, the unpaid shares may be forfeited and the shareholder no more remains a shareholder. Okay. Next. Perpetual succession. Next feature, third feature is perpetual succession. Perpetual succession means that the members of a company may keep changing from time to time, but that does not affect the company's continuity. Okay, so for example, if I hold the share for some period of time, for example, for 1 year or 2 years, so after that I will sell my share to some other one. So then the shareholding person will be changed. So and also sometimes the shares won't be purchased or the shares won't be bought by anyone. Then even that the shares holding of the shares person is differs or even the shares are not purchased by anyone, the existence of the company doesn't change. The existence of the company will be continued. Okay. And the death or insolvency of individual members does not in any way affect the corporate existence of the company. Even if the shareholders dies, the company won't die. Its existence will be continued. So to indicate there is some case like Gopalpur Tea Company Limited versus Penhock Tea Company Limited 1982. We can quote this case law in order to explain the concept of perpetual succession in the companies. Okay, in exams they will ask what do you like. In order to prove the perpetual succession, they'll ask quote some example. We can explain all the theory whatever given here, and we can quote this case law. So then it will give a good marks for you all. And members may come and go, but the company can go on forever. So like what I said in the earlier lines, members will come and go. The shareholding will transfers from one person to other person, but the company's existence will continue for a longer period of time. There are many companies in India which were formed 100 years before, not the people who have formed or no, so no more there, but the company remains. So there are some companies which have 121 years of experience, 150 years of experience. So the people who founded the company might die, but the companies are still continuing. So this is what the concept of or the future of perpetual succession means. Separate property as separate owner. Okay, this is the fourth feature. A company, being a legal person, is capable of owning, enjoying, and disposing of property in its own name. The company becomes the owner of its capital and assets. So the shareholders are not the several or joint owners of the company property. So what they are saying means, if a company buys any property or any shares, that will be on the name of the company only. Those assets are not, those assets are not belong to these shareholders anymore. Okay, the company is the real person in which all its property is vested and by which is controlled, managed, and disposed of. Bacha F. Gujdar versus CIT Air. Okay, what they are saying is separate property as separate owner. Company property and company assets does not belong to the shareholders. Company, all the assets and all the shares of the company, on them only company have the right. No shareholders will have any right. So, in order to quote this line, in order to strongly say this line, we can quote the case law, Bacha F. Gujdar versus CIT Air. The property is vested in the company as a body corporate, and no changes of individual membership affect the title. The property, however much the shareholders may command to remains vested in the company, and the company can convey, assign, mortgage, or otherwise deal with irrespective of these mutations. So shareholders will come and go. That doesn't affect the company's assets or company shares. So the company can use the assets. The company can sell the assets. The company can mortgage the assets. The company can keep the assets as collateral security in order to bring some loan or something else. Okay. Next, and the next feature is the transferability of shares. In case of companies, the shares should be capable of being easily transferred accordingly. So accordingly, the Companies Act 2013 in section 44 declares the shares or debentures or other interests of any member in a small company shall be movable property, transferable in the manner provided by the articles of the company. Thus, incorporation enables as a member to sell his shares in the open market and to get back his investment without having to withdraw the money from the company. This provides the liquidity to the investors and stability to the company. So transferability of the shares means when a person who buys the shares, he has the right to sell the shares to other person. So he has the buy the from that person, another person can buy the shares without drawing the money from the company. So this is what they call as the transferability of the shares. They can use the shares, they can sell the shares, they can buy the shares without withdrawing money from the company. Okay, the value of the share will be held with the company, and this share can be moved from one person to another person. Common seal, another feature. Prior to Companies Amendment Act 2015, the common seal is a seal used by the corporations as the symbol of its incorporation and also a statutory requirement for a company. So before Companies Act 2013, the common seal is a seal used by a corporation as the symbol of its incorporation. Common seal used as a symbol of incorporation. Incorporation means the starting of a company. As a departure from this concept, the Companies Amendment Act 2015 has deleted the requirement of having common seal compulsorily. Now it's optional. So Companies Act, after some amendments coming in 2015, so the what they done is common seal making compulsory of common seal is removed. Okay, so common seal compulsory, now it's optional. They can keep the common seal or not. It depends on their interests. So, however, where the company has opted to have a common seal, the same shall be used at provided under the Act or the articles. After this amendment, in case a company does not have a common seal, the authorization shall be made by two directors or by a director and the company secretary wherever the company has appointed a company secretary. So, if the company have common seal, it can continue as in the way as it like. But if the company chooses the option to not have common seal means, then what they are saying, then Companies Act 2013 what is saying means, when a company does not have a common seal, then it requires the authorization of two directors or by director and the company secretary, or one director and one company secretary, where the company has appointed a company secretary. So at least two directors. If the company appointed a company secretary means one director and one company secretary must give the authorization. So those people who were studying the company secretary also, they have this kind of works also. So giving authorizations for the companies, okay, for practicing company secretary. So next feature is lifting of the corporate veil. So the farce lifting the phrase lifting the veil is looking behind the company as a legal person. That is disregarding the corporate entity and paying regard instead to the realities behind the legal facade. Where the law ignores the company and concern themselves directly with the members or managers, the corporate will may be said to have been lifted. Only in appropriate circumstances, the courts are willing to lift the corporate wage and that too when questions of control are involved rather than merely question of ownership. The following are the cases where the company law disregards the principle of corporate personality or the principle that the company is legal entity distinct and separate from its shareholders or members. So in the law relating to or trading with the enemy, where the test of control is adapted. So in certain matters, so concerning the loss of taxes, duties and stamps particulars, where question of the controlling interest is an issue, where the companies form the companies as their subsidiaries to act as their agent, the application of doctrine may operate in favor of such companies depending on the facts of particular case. Suppose a company acquires a partnership concern and registers it as a company, which becomes a subsidiary of the acquiring company in an action for compulsory acquisition of the business premises of subsidiary. So it was held that the parent company, so which through itself and nominates held as shares, was entitled to compensation maintain action for the same. Smith, Stone and Knight Limited versus Lord Mayor, etc. of Birmingham. So what they are saying is the phrase lifting the veil is looking behind the company as a legal person. So means we are company is separate from its persons. So that's what they are saying. The phrase lifting the veil is looking behind the as a legal person, that is disregarding the corporate entity and paying regard instead to the realities behind the legal packet. Where the law ignores the company. Okay, law ignores the company and concern themselves directly with the members or managers. The corporate will may be said to have been lifted only in appropriate circumstances. Means in some particular situations, what it is doing means in some scenarios will be there. In those scenarios, the company and the members are not separated. The law will be seen them both them together. So if in some bad scenarios there will be there some illegal activities are going to conducted by the company. So then in those cases, what the law is saying means in those when a company direct motto is conducting some illegal activities or conducting some activities with terrorists or doing some drug mafia, then the corporate veil is not lifted. Then the company and the members are not separated. They are both together will be looked forward. They are both together taken together and given the judgment. So that is what they are saying of lifting of the corporate veil. In some exceptional situations, so the distinction, so the separate, the legal entity is not, the legal entity concept will not be considered. Both the members, both the shareholders or the members and the company together will be chosen, will be seen in the eyes of law. What they are saying is that only, okay. Only in appropriate circumstances, the courts are willing to lift the corporate veil, and that too when questions of control are involved in rather than merely a question of ownership. The following are the cases where the company law disregards with the principle of corporate personality or the principle of that the company is a legal entity distinct and separate from its shareholders or members. So these are the cases. So up to A to H are the cases. In these cases, the company going to see both the legal entity, both the company and the members both were the same. If a company involved in the following issues, then the action will be taken both on the company and the members together. So earlier I said in one future that when it comes to a limited liability concept, so the shareholder when holds a 10% of the share, so his liability only up to 10 rupees only. Remaining 90 rupees liability is related to the company. But when the company is dealing with some illegal activities, here the shareholder or the member have to take the 100% responsibility on him. So those were the cases. These are the cases. What are the cases means? In the law relating to trading with the enemy where the test of control is adopted, so this is what is that enemy. When the company is trading with the enemy, then the members are included. In certain matters concerning the law of taxes, duties and stamps, particularly where the question of controlling interest is an issue. So when the company is unable to pay the taxes or when the company is not paying its duties and stamp duties, then also the members will be included. So where the companies from the form, the other companies as their subsidiaries to act as their sometimes one company is formed. So for us, one more another company is formed for its subsidiary company. So the application of the doctrine may operate in favor of such companies depending upon the facts of particular case. Suppose a company acquires a partnership concern and registers it as a company. So, okay, which becomes a subsidiary of the acquiring company. Okay, in an action for compulsory action of the business premises of the subsidiary, it was held that the parent company, so which through itself and the nominee held all the shares, was entitled to compensation, maintain action for the same. So, for example, if a company is formed and a subsidiary is established, or when a partnership form is also established, and if that particular partnership form is doing any illegal activities or any fraudulent activities, or unable to pay the duties and taxes which it is subjected to pay, then the responsibility of the partnership form is also come to this main company, or the subsidiary company subsidiary company activities related responsibilities will also come to this main company. That is what they are trying to say. So where the courts find that there is avoidance of welfare legislation, it will be free to lift the corporate veil. So welfare legislation activities, if it missed any welfare legislation rules, in that also the members of the company were the same. For this saying strongly, they are using the case law Workmen of Associated Rubber Industry Limited versus Associated Rubber Industry Limited AIR. Next, E, the court is invariably lift the corporate veil or disregard the corporate personality of the company to protect the public policy and prevent transactions contrary to the public policy. Corners versus Corners Limited. So in this particular case, what is happened? Corners Limited is a company, and Corners are the members of the company. So the company is unable to follow that. The Corners Limited is unable to follow the public policies of that state in which it is established. So then the court said that the Corners, the members, only responsible for the company behaving like that. So we are going to take charge on Corners also like them. Okay. Under the law relating to exchange control, the court pierces the corporate veil in quasi-criminal cases in order to look behind the legal person and punish the real person who have violated the law. So in these particular cases, when the company violates some regulations which it is subjected to follow, then the court sees the person who is responsible for making the company to do that particular activity, concentrate on it and punishes that particular person. Where the use of an incorporated company is being made to avoid legal obligations, the court may disregard the legal personality of the company and proceed on the assumption as if no company existed. Okay. In the latest judgment, the Honorable Supreme Court of India, in the case of the Estate Officer UT Chandigarh versus ESYS Information Technologies Limited, held that the lifting of corporate veil could be done in the case of the transfer of the shares of the company, which actually was a sale of land, which the original allottee was prohibited to do so. So lifting of corporate veil when it happens means if I was a shareholder for that particular company. So and when I'm holding the shares, if a particular mistake is happened means during the period of holding my shares, then it will be the corporate will be lifted and both this company and me will be the same. If I sold the shares to particular persons and for after some period of time the mistake is happened, then I was not subjected to that particular mistake. Okay, that is what it's saying. Okay. Nature of business organization. So these were the features of lifting of corporate veil. It might so some case laws will be asked in the exam with some practical questions. So if you remember all these rules means, then it will be very easy you to answer for that question. Okay. Next, nature of business organization in India. So what is the nature of business organization? There are various types of organizations doing business in India. Profit may not be motivate or objective where there is a substantial government investment. This sector is also called a social sector as it cater to the needs of the society. Some business organizations will be there, NGOs, non-government organizations. Their main objective is not earning profit. They're subjected to work for the benefit of the society. So we may categorize public sector as follows of the basis of the government ownership. So the companies are based on their activity, based on the mode of the company. The companies are categorized in the following ways. The first one is public sector. This sector comprises of the following. The following will be regarded as the public sector companies. Government departments like railways, ordnance factories, postal services, etc. So statutory corporations set up and run by the government, that is the Reserve Bank of India, created by the Reserve Bank of India Act 1934. Companies with majority holding by central government or state government having independent management by board of directors. So these are all the government companies. I think you have idea. And also the government company holding majority of the shares. Majority means more than 50%, and they are taking in charge of the management of the company. Those are also called as the public sector companies. So after qualifying the CMAs, so we will get some what is that campus placement, some PSU companies. So those people who get the job opportunity in PSU, so are very lucky. So they will be very good. The treatment for the employee will be very good, and they will hold some good decent respect in the society also. Joint sector. So where government have investment between 26 to 50%. So if the government holds more than 50% means, then it will be called as a PSU. If the government holds 26 to 50% of the share means, then it is called as a joint sector. Companies may be classified on the basis of their incorporation, number of members, size, basis of control, and on motive on the basis of incorporation of the companies. So it may be classified into charter companies, statutory companies, and registered companies. So based on its holding, the company will be called as chartered companies, statutory companies, registered companies.
On the basis of liability, it may be the companies limited by shares or guarantee and unlimited liability companies. And on the basis of liability, it is called as company limited by shares or guarantee and unlimited liability companies. Further, on the basis of number of members, they may be classified into one person company, private company, public company. And on the basis of members, it is called as one person company, private company, and public company. On the basis of size, they may be divided into small companies and other companies. And on the basis of the size, it may be divided into small companies and other companies. And on the basis of control, they may be classified into holding company, subsidiary company, and associate company, and may also under the categories like non-profit companies licensed under Section 8, government companies, foreign companies, dormant companies, nidhi companies, investment companies, producer companies. So on the basis of the companies divided on the basis of members holding, on the basis of liability, on the basis of size, on the basis of holding in different areas, in different bases, the companies are called in different formats. That is what all about the joint sector. And coming to promotion of a company, as per Companies Act 2013, persons whose name appears in the prospectus are identified by the company in the annual return has control directly or indirectly over the affairs of the company, either as a shareholder or a director, and according to whose direction, advice, or instructions the board of the directors are accounted to act. So if a person whose name is given in the prospectus, so those persons are direct have the full access for all of the activities of the company, and the board of the directors and every person are subject to follow according to the instructions given by that particular person. A person should not be regarded as a promoter if he or she acts in its personal capacity. If he acts in personal capacity, we should not take it into consideration. So as per the Securities Exchange Board of India, SEBI, persons who are in control of the issuer or instrumental in the information of the plan or program pursuant to which specified securities are offered to the public, the persons whose name appears in the offer document are known as promoters. So who are called as promoters? As per SEBI, they are saying as issuer or who are in control of the issuer or instrumental in the formulation of a plan or program pursuant to which specified securities are offered to the public. Those who are involved from the beginning, those who are involved in the issuer, in the control, those who are in the control of the issuer or instrumental in the formulation of the plan or program pursuant to which the specified securities are offered to the public. Those securities which are offered to the public in the formation of those securities who are involved. So they were called as promoters. Promoters agreement or memorandum of understanding. Now we are going to learn. So when promoters decide to do a business in the nature of a company, they will be meeting and deciding on various issues, and ultimately they will be choose to make memorandum of understanding, though it is not mandatory. So promoters means the first persons who start the company, they were called as promoters. So when they are decided to do a business in a company format, they will uh, create a memorandum of understanding, even it is not mandatory for but for their sake. So promoters or any of the promoters can make contracts in his own name of for the benefit of the proposed company So promoters or any promoters can name contracts on behalf of the company for the sake of benefit of the company. So once registered promoter will disclose the contracts. Promoter is only duty bound to disclose any interest in the company to any interested person and will not make any secret profit. So promoters will 100% work for the benefit of the company, but not for his secret profit. So promoters can also make an agreement which will mention various issues relating to formation of the company and the rights and liabilities of the company inter se. So promoters may decide to prepare and sign a memorandum of understanding or memorandum of agreement, also called as promoters agreement, while memorandum of understanding is not enforceable under the law. So promoters can sign any memorandum of understanding or any memorandum of agreement. Having a memorandum of understanding or memorandum of agreement is not mandatory, and promoters may decide to prepare two initial documents. So memorandum of understanding MOU and MOU are not mandatory, but the promoters may decide to prepare two initial documents. At the beginning of the company, promoters have to prepare two documents. They were so memorandum of association and articles of association. Okay, so these two documents must be prepared by the promoters. So a company may be incorporated as one person company OPC, a new concept altogether in the Companies Act 2013. Private company or a public company, depending upon the number of members joining it. So again, it may either be unlimited company or maybe limited company by the shares or by guarantee or by both. So a company can form into anything based on its availability. The memorandum and articles of association of a company are the most important documents for the formation of a company and for its functioning thereafter. So MOA and MOU plays vital role in the formation and functioning of the company. This may be came as bit. This may come as bit. Okay. The memorandum and articles of association. So the memorandum of association contains the name, situation of registered office, objects, capital and liability and subscription clauses. So what there will be in memorandum of association means name, company name, situation of registered office, where is the place of registered. So place of registered office, objects, what are the objects of the company, capital and liability and subscription clauses. All these were in mentioned in the memorandum of association. Coming to the articles of association or its bylaws or rules and register and regulations that govern the management and internal affairs, the conduct of its business. So how to function, how to run. So what are the rules to follow by the company? All these are given in the articles of association. Both the documents are required to be registered with the register of the companies at the stage of the incorporation of the company. So both the memorandum of association and articles of association so must be registered with the register of the companies. Before dealing with a company, so it is advisable to read the memorandum and articles of the company to understand the aspects such as powers of the board, scope of the company's activities, etc. So when if any person going to deal with the company or entering into any agreement with the company, it's better to read the articles of association and memorandum of association related to that company. Okay, so on its relationship with the outside world, since memorandum sets out the constitution of a company and is therefore the foundation on which the structure of the company is built. So it defines the scope of the company's activities and its relations with the outside world. So memorandum of association will define everything related to company and also the relations of the company with outside world. Company secretary in employment should work within the four walls of the memorandum of association and also subjected to the provisions of articles of association. A company secretary is subjected to work with both memorandum of association and articles of association. People who are pursuing the company secretary, so they will have this opportunity to work with the company after their completion of CS. Classification of companies. Companies may be classified into various classes on the following basis. So on the following basis, companies are classified into different types. First, on the basis of incorporation, how many types the companies are classified? Statutory companies. So these are the companies which are created by a special act of legislature. So these statutory companies are created by special act of legislature. Example, the Reserve Bank of India, State Bank of India, the Life Insurance Corporation, the Industry Finance Corporation, or Unit Trust of India, State Financial Corporations. These are mostly concerned with the public utilities. Example, railways, tramways, gas, electricity companies, enterprises of national importance. The provisions of the Companies Act 2013 do not apply to themselves. The Special Act specifies such application. So, Banking Regulation Act 1949 is a special legislation company concerning the banking companies. So, the 2013 Act doesn't directly apply to the statutory companies unless provided those acts have to specifically mention that 2013 companies regulations will also apply to them like that. Registered companies. So registered company means these are the companies which are formed and registered under the Companies Act 2013 or were registered under any other earlier Companies Act. So many statutory companies has converted into the companies which the So which they issue public issue. So if a company is registered under the Companies Act 2013, it is called as a registered company under 2013. Or if a company which is registered before the Companies Act 2013, it is also called as registered companies. On the basis of liability, so companies are divided into company limited by shares. Section 2 plus 22 of the Companies Act 2013 defines that when the liability of a members of a company is limited by its memorandum of association to the amount, if any, unpaid on the shares held by them, so it is known as a company limited by shares. So the shareholders may be called upon to contribute only to the extent of the amount which remains unpaid on his shareholdings. So his separate property cannot be encompassed to meet the company's debts, unlike a proprietorship or partnership. So if a company is limited by shares, means a company, for example, a person holding a share value of 10 rupees. In that share value, in the first call, second call, third call, so up to 3 calls, he paid 7 rupees only, and remaining 3 rupees is pending from him. And the company is dealing with difficult issues, and the company have to have some liabilities outside. So in order to meet those difficult conditions, then the company may call his remaining liability from the shareholder 3 rupees, but not the entire liability of the company. So company limited by guarantee means section 2 plus 21 of the Companies Act 2013 defines it as the company having the liability of its members, so limited by the memorandum to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of its being wound up. Thus, the liability of the member of a guarantee company is limited up to the stipulated sum mentioned in the memorandum. Members cannot called upon to contribute beyond the stipulated sum. This is similar to LLP. So means limited by guarantee means if a company has 100% of liability, then the members are all are subjected to pay the 100 rupees liability by dividing share between them. So this is what company limited by guarantee. And the company is limited by shares means up to where the his share applicable only up to that extent he will pay the amount. If it is limited by guarantee means the shareholders has to take the entire responsibility in paying the company's debt. That is what company limited by guarantee. So when you are becoming a partner to a company, choose whether you want to join in the company limited by liability or limited by guarantee. Based on your power or based on your stamina, you can choose to join in that company. Next, unlimited company. Section 2 clause 92 of the Companies Act 2013 defines unlimited company as a company not having any limit on the liability of its members. In such a company, the liability of a member ceases when he ceases to be a member. The liability of each member extends to the whole amount of the company's debts and the liability, but he will be entitled to claim contribution from the members. So here what they are saying means company limited by guarantee means whatever the amount that is mentioned in the memorandum, that up to that amount the shareholders have to pay the debt. And unlimited company means whatever the liability that is there for the company, the shareholders have to take that entire responsibility by the shareholders. So that is the differences between company limited by liability, company limited by guarantee, and unlimited company. Limited by shares means what is the share value, to that extent only he is liable. Company limited by guarantee means whatever the amount that is guaranteed in the memorandum of association, to that amount only the shareholder is liable. Unlimited company means if the company has only how much amount of liability, for example $10,000 is the liability for the company, means the $10,000 is subjected to be paid by the shareholders. In case of limited by guarantee means it is mentioned in the memorandum of association like the company's liability is $10,000, but all the shareholders are subjected to clear the amounts up to $8,000, means then all the members have to pay up to the $8,000. And if the company is limited liability means, so limited liability means if the share value is only 10 rupees, but $10, but the company's liability is $10,000, then the member will be paid only up to the $10 only. This is the differences between unlimited company, company limited by guarantee, and unlimited by guarantee and company limited by shares. Okay. And on the basis of members, one person company. So if a company, the concept of one person company has now been introduced in India through section 2 clause 62 of the Companies Act 2013, thereby enabling entrepreneurs carrying on the business in the sole proprietor form of business to enter into a corporate framework. So though this concept is new in India, but it is already be part of many other countries like China, Australia, Pakistan, and UK, etc. According to section 2 clause 62 of the Companies Act 2013, one person company means a company which has only one person as a member. A company formed under the one person company may be either a company limited by shares, a company limited by guarantee, or a company unlimited company. One person company is a hybrid sole proprietor and a company form of business and has been provided with concessional or relaxed requirements under the company. When a company is formed by single person, so whether by company limited by shares or company limited by guarantee or company and unlimited company, so if the company is wholly is run by only one person, means then it is called as a one person company. Features of one person company: only one shareholder. So only a natural person who is Indian citizen and resident in India shall be eligible to incorporate one-person company. So that one person must be Indian citizen. So he should be resident in India. Nominee for the shareholder. So the shareholder shall nominate another person who shall become the shareholder in case of the death or incapacity of the original shareholder. Such nominee shall give his or her consent, and such consent for the being appointed as the nominee for the sole shareholders. So only a natural person who is the Indian citizen and resident in India, so shall be nominee for the sole member of a one-person company. So for this one person, there should be another nominee, and that nominee should also express his consent that he is willing to work as nominee for this one person, for this one person. So if this one person dies or anything happens, or disease remains, that all the related liability or all the profits related to that person will come to this nominee. Director must have a minimum one director. The sole shareholders can himself be the sole director. The company may have a maximum number of 15 directors. So directors might be 15 for the one person company. The one person company might have only one person as sole proprietor, but it can have 15 directors or minimum one director. So that minimum one director can also be this one person only. So as given that the liability of the limited, the one person company is meant for sole entrepreneurs, there must be a nominee to enable perpetual existence of OPC. So one person company, various exemptions have been given by the central government to OPC, such as exemption from holding to annual general meeting of the company. Financial statements and a board's report can be signed only by one director. It does not need to include cash flow statement as part of its financial statement. There are some industry specific advantages, but taxes are to be paid at a flat rate on profits. So for one person company, there are some industry specific benefits, but the tax rates have to be paid at flat rate. Whatever the rates applicable to all other companies, those rates will be applicable to the one person companies. Flat rate means for the individual. So there might be chances whatever the tax rates that are applicable for the individual, those rates will also be applicable for the one person company. Private company, section 2 clause 68. According to section 2 clause 68 of the Companies Act 2013, a private company means a company having a minimum paid up share capital as may be prescribed, and which may by its articles restrict the right to transfer shares. Private company must have minimum share capital, but articles shall also restrict that the share should not be transferred. Share restricted to transferred shares. So the shares, when the private company wants to transfer the shares, the articles must be restricted. Should not restrict means should stop. So except in case of one person company limits the number of its members to 200. So provided, except in case of one person company, okay, limits the number of its members to 200, provided that where two or more persons hold one or more shares in a company jointly, they shall for the purposes of this clause be trusted as a single member. Provided further that, so persons who are in the employment of a company, so the persons who having been formerly in the employment of the company were members of the company while in that employment and have continued to be the members after the employment ceased shall not be included in the number of members, and prohibits any invitation to public to subscribe for any of the company. So here what are they saying means, according to section 2 clause 68 of Companies Act, private company means a company having minimum paid up share capital must be there as may be prescribed, and which by its articles restrict the transfer shares, and also except in case of what they are saying, except in case of one person company limits the number of its members to 200. So number of members might be for a private company 200. Okay, for only one person company there is also chance in one person company they can form a private company. But if it is not a one person company but a private company, here the members can be for a private company up to 200 only. It should not extend more than 200 members for a private company. And also what they are saying, for the purpose of this clause, so be related as a single member, provided further that persons who are in the employment of the company, so and persons who having been for, and these are the persons should become as the members of the private company. Persons who have been formerly in the employment of the company were members of the company while in that employment and have continued to be member after employment ceased, so shall not be included in the number of members. So one person is there and he is used to work for the employment, and after his employment is closed, so then he is not subjected to become a member of this private company again. Prohibits any invitation to the public to subscribe for any securities of the company, and also the private company is not subjected to invite any public persons to subscribe to take the shares of this private company. Exception to limited liability. Section 3A provides that if the number of members of a private company is reduced below 2, and okay, if the number of members, minimum numbers 2 and maximum numbers are 200, if the minimum number of members are reduced below 2, then and the business is carried on for more than 6 months, and the business is carried for more than 6 months, while the number of members is so reduced, and every person who is a member of the company during this period shall be severally liable for the payment of the whole debts of the company contracted during that time, and may be severally sued for therefore. So what they are saying is, except to limited liability. There is no limited liability. So if the number of members are reduced below 2, so section 3 provides that if the number of members of a private company is reduced below 2 and the business is carried out for more than 6 months, so means one person is there in a private company and the business is also carried for more than 6 months, and while the number of members is so reduced, and in the same way the numbers are reduced to below 2, so every person who is member of the company during this period, so in this period, if the business is carried for more than 6 months and the number of members are reduced below 2, and shall severally whatever the business expenses, whatever the business liabilities incurred on the name of the company, those all expenses and those liabilities are should be responsible by that single person, and he is a subject to pay all those expenses. That is what they are communicating. Public company. So what is the public company? According to section 2 clause 71 of the Companies Act 2013, a public company means a company which is not a private company. If a company is not a private company, it will be called as a public company. As a minimum paid up share capital as may be prescribed, it should have some minimum paid up share capital. So 7 or more members are required to form the company. Minimum 7 members are there should form a public company. So in case of a private company, minimum numbers are 2. In case of a one-person company, minimum number is 1. So provided that a company which is a subsidiary of a company not being a private company shall be deemed to be a public company for the purposes of this act, provided that the company which is a subsidiary of a company. So for example, there is one company and for its a subsidiary company is there. So provided that the company which is a subsidiary company of a company not being a private company shall be deemed to be a public company for the purposes of this act. So even where such subsidiary company continues to be a private company in its articles, a tablet differences between private and a public company is placed below. A tablet differences between private and public company is placed below. Okay, so what are the differences between private and public company are given overview is given here. So shareholders. So for private company minimum 2, maximum 200. So for public company shareholders minimum 7, maximum is no maximum. So they can more any more based on their wish. Directors minimum 2 for private company. So maximum directors is 15. For public company minimum is 3 and maximum is 15. Maybe increased with the special resolution. And the public company can pass the special resolution and the maximum number of directors can be increased. Finance. So cannot rise from public. So for private company, the finances cannot be raised from the public. The members only have to take the finance by themselves. And public company can raise the finance from outside. Transfer of shares may be restricted, cannot be restricted. The shares can be transferred from one person to another person in case of public company, and it might be restricted in the private company. Name. Use the suffix private limited. For all private companies, at the end, they have to give the name suffix private limited. For public companies, it has to give the suffix limited. So what do you mean by small company? So according to section 2 clause 85 of the Companies Act 2013, a small company means a company so other than a public company. If it is not a public company and it is not a private, it might be private company, is called as a public small company. Paid up share capital of which does not exceed 50 lakhs. The paid up share capital must be below 50 lakhs or such higher amount as may be prescribed, which shall not be less than 10 crores. So which shall not be more than 10 crores. So the paid up share capital must not be 10 crores if it is specified. Otherwise, the paid up share capital should always be less than 50 lakhs. Turnover of which as per its profit and loss account for the immediate preceding financial year, so does not exceed 2 crores or such higher amount as may be prescribed, which shall not be more than 100 crores. Turnover should not exceed 2 crores. If anything is prescribed, it should not exceed 100 crores. So it should have less than 50 lakhs paid up share capital and it should have turnover less than 2 crores provided nothing in this clause. So provided that nothing in this clause shall apply to, so a holding company or a subsidiary company, a company registered under section 8 or a company, a body corporate governed by a special act. So the following companies, even it does not does not subject to the conditions. So below conditions. So above conditions, it can be called as a small company only. Okay, even if its paid up share capital is less than no more than 50 lakhs or the turnover is more than 2 crores, these three companies are called as the small company only. That is a holding company or a subsidiary company, a company registered under section 8, and a company or by a body corporate governed by any special act. Next, on the basis of control, how the company is divided or called holding company and subsidiary company. Holding and subsidiary companies are related to terms. A company is a holding company of another if the other is its subsidiary. So if one is holding and if another is subsidiary, means if the for the subsidiary it is called as a holding company. So according to section 2 clause 46 of the Companies Act 2013, holding company in relation to one or more other companies means a body corporate of which such companies are subsidiary companies. According to section 2 clause 87 of the Companies Act 2013, subsidiary company or a subsidiary in relation to any other body corporate, that is to say that a holding company means a body corporate in which the holding company controls the composition of the board of the directors or exercises or controls more than one half of the total voting, so either at its own or together with one or more of its subsidiary companies, provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be prescribed. So holding company means if a holding company controls the management in the subsidiary company, or if a company controls the composition of board of directors, or if a company control anything in this another company means, then for this another company, subsidiary company, it is called as a holding company. So this holding company and subsidiary company concept is clearly explained in paper 17 CMA. So you can see the topic. If you read the topic means, you will understand very clearly. So on the basis of listing in the recognized stock exchange. So based on the recognized stock exchange, the company is divided into listed company, also widely held. According to section 2 clause 52 of the Companies Act 2013, a company, a listed company means a company which has any of its securities listed on any recognized stock exchange. So if any on any recognized stock exchange, if a company shares are listed means, then it is called a listed company. Whereas the word securities as per section 2 clause 81 of the Companies Act 2000 has been assigned the same meaning as defined under clause H of section 2 of the Securities Contract Act 1956. Whatever the word securities defined in Securities Contract Act, the same meaning will be appeared applicable for these securities also. Such class of companies which have listed or intended to list such class of securities as may be prescribed in consultation with the Securities and Exchange Board shall not be considered as listed companies. Okay. For the purpose of the proviso to clause 52 of section 2 of the Companies Act 2013, the following classes of the companies shall not be considered as listed companies, namely, so public companies which have not listed in their equity shares or not recognized as stock exchange but have listed there. For the purpose of clause 52, clause 2 of the companies, the following classes of companies shall not be. So the following companies A, B, C. So these three sections are not called as the listed companies because of the following conditions. What are they? Public companies which have not listed their equity shares on a recognized stock exchange but have listed their non-convertible debt securities issued on private placement basis in terms of SEBI. So non-convertible redeemable preferential shares issued on private placement basis in terms of SEBI. So if the public company is not listed their shares on the SEBI means, it is not called as a listed company. Private companies which have listed non-convertible debt securities or private placement on basis of recognized stock exchange in terms of SEBI. So and also the private companies which listed the non-convertible debt securities, even they listed in the SEBI, but they are non-convertible debt securities means those are not called as listed companies. Public companies which have not listed their equity shares on a recognized stock exchange, so but whose equity shares are listed on a stock exchange in a jurisdiction as specified under section 223. So public companies are there, so their listed securities are not recognized on or equity listed shares, listed equity shares. So on a recognized, they have not listed their equity shares on a recognized stock exchange means there will be some recognized stock exchange. So if the public company is not listed their equity shares on that particular stock exchange means, it will be not called as a listed company, but whose equity shares are listed in a stock exchange in a jurisdiction. So if the company is established in a particular jurisdiction, if there is some stock exchange means, if its liquidity shares are listed in that particular stock exchange means, it will be called as listed company. What is unlisted company? Unlisted company means company other than the listed company. The company which is not a listed company, it is called as unlisted company. Simple. That is. They are also called as closely. So unlisted company, other name is closely held companies. It may be mentioned here that out of the substantial number of companies registered as public companies who can approach the capital market, a very small percentage of the companies have issued shares to public and are listed. It means although promoters are forming public limited companies, so they are not interested or ready for public issues. Few promoters don't want to dilute their stake to public. So other types of companies. So what are the other types of companies? Number one is government company. So according to section 2 clause 45 of the Companies Act 2013, a company, government company means any company in which not less than 51% of the paid up share capital is held by the central government or by the state government or governments, or a partly by the central government or partly by one or more state governments, and includes a company which is a subsidiary company of such a government company. Coal India Limited is a government company, whereas Coal India has many subsidiaries which are also government companies. If a company holds more than 51%, if the government holds more than 51% on any company, then it is called as a government company. And the subsidiary of this company, government holding company, will also be called as the government company itself. And foreign company. According to section 2 clause 42 of the Companies Act 2013, foreign company means any company or body corporate incorporated outside India. Okay. So which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, conducts any business activity in India in any other manner. So means the company, what they are saying, what when we call a company as foreign company means any company or body corporate incorporated outside India, but it's doing the place of business in India. The incorporation is outside India, means the company created outside India, but its place of business in India. So that type of companies are called as the foreign companies. So whether it can directly run its business or it can directly do the business, so with the help of any agent. For example, is Facebook. So it headquarters is outside, but it is also doing the business in India. That's it. Associate company or Accenture or any other companies, their headquarters is outside, but they're incorporated in India and they're conducting the business here. Associate company. According to Section 2 Clause 6 of the Companies Act 2013, the associate company in relation to another company means a company in which the other company has a significant influence. So, but which is not a subsidiary company of the having such influence and includes a joint venture company. As per explanation given under the section, the clause significant influence means control of at least 20%. 20% of the total share capital or the business decisions under an agreement. If a company has a control at least 20% on other company means then this company will be the associate company for this company, and it will take a major decision on the business agreement of this company. Yeah, dormant company. So where a company is formed and registered under this act for a future project or to hold an asset or intellectual property and has no significant accounting transaction, such a company or an inactive company may make an application to the registry in such manner as may be prescribed for obtaining the status of a dormant company. So dormant company is nothing but where a company is formed and registered under this act for a future project or on some purpose a company is formed, and when the purpose is served, the company is dissolved, then that type of companies will be called as dormant companies. Nidhi companies, company which has been incorporated as a nidhi with the object of cultivating the habit of thrift, cost cutting and savings among its members, receiving deposits from and lending to so its members only, so for their mutual benefit, and which companies which such rules as prescribed by the central government for regulation of such class of companies. So companies which has been incorporated as a nidhi with the object of cultivating the habit of thrift, cost cutting, and savings among its members, receiving deposits from and lending to its members only for their mutual benefits, and which complies with such rules or as prescribed by the central government. The company which is formed for the benefit of the members and also which follows the rules of the central government, then it is called as nidhi company. Public financial institutions. According to Section 2, Clause 72 of the Companies Act 2022, the following institutions are to be regarded as public financial institutions. So, the following are the public financial institutions. What are they? The Life Insurance Corporation of India, established under the Life Insurance Corporation Act, the Infrastructure Development Finance Company Limited, so specified company referred to in the Unit Trust of India, so transfer of undertakings and repeal Act 2002, institutions notified central government under section 4A2 of the Companies Act 1956, so repeal under section 465 of this act. Such other institutions as may be notified by the central government in consultation with the Reserve Bank of India, provided that no institution shall be so notified unless so it has been established or constituted by or under the central or state act, or not less than 51% of the paid up share capital is held or controlled by the central government or by the state government or the governments, or partly by the central government and so partly by one or the more state government. Joint venture company means, so the term joint venture has also been defined to mean joint arrangements where the parties who have joint control of the arrangements have the rights to net assets of the arrangements. So if a company is formed by the joint arrangement of two parties, and they have equal rights on the assets that related to that company. Means that company is called as joint venture company. Means for a particular purpose the company is formed for particular venture, for completing for particular venture the joint venture company will be formed. It is the formed on the basis of the joint venture agreement between two or more companies and registered as a company with the joint venture partners share the responsibilities and involvement. They may be arrangement of venturing a business jointly without forming a company. So this is called a non-corporate joint venture or a contractual joint venture. So this joint venture sums can also be seen in the financial accounting. Joint venture chapter will be there. Consignment joint venture. Next, non-profit company. So section 8 company is a company established for company, commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any other object. So if a company is established for fulfilling of any of the above said objects, provided the profits, if any, or the other income is applied for promoting only the objects of the company, and the company which is funded for the benefit of the objectives of the company, means for the benefit of the society. So, and no dividend is paid to its members. Section 8 companies are registered under the Companies Act. So, whatever the profits received by the company are used for again for the purpose of the company, but not sharing by the any of the members. So, then that type of companies are called as non-profit company. Sectoral companies. So sectorial companies are companies registered under the Companies Act but specializing in particular sector. So which is regulated by the registry authority of the government. For government will authority authorizes some sectors. For taking care of that particular sector, a company is formed means that is called as sectorial companies. So these are the companies which are required to follow the provisions of the Companies Act as they are registered companies and have to follow the sectorial legislation. So as the law applies to that sector, they have to follow both the regulations. One is Companies Act regulations and other one is particular sector regulations. So therefore we have banking company which has also follow the Banking Regulation Act as well as Companies Act. So for example, banking companies like SBI, HDFC, all these banks, they have to follow the banking regulations and also they have to follow the Companies Act 2013 regulations. So act are also subject to RBI directives. So RBI being the regulator, so same as in the case in for companies dealing in insurance and electricity, etc. Okay. Next, non-banking financial company (NBFC). So with the growth in the financial sector during the last 3 decades, NBFC have been recognized as a large sector of business. Okay, non-banking financial company. Non-banking financial company is a company registered under the Companies Act. It will be registered under Companies Act. It engaged in the business of loans and advances. So giving loans and advances, acquisition of the shares or stocks or bonds, debentures, securities issued by the government. So whatever the government issues, shares, stocks, bonds, so will all it will be acquired by it, or local authority or other marketable securities of a like leasing, hire purchase, insurance business, chit business, but does not include any institutions whose principal business is that of agricultural activity, industrial activity, purchase or sale of any goods other than securities, or a non-banking institution is a company and has principal business of receiving deposits. Okay. Banking companies, a company registered under the Companies Act and engaged in the banking business as stipulated under Banking Regulation Act. It is registered under the Companies Act and it works as per the regulations given by the Banking Regulation Act. It is called as banking company. In India, no company can commence banking operations without having a banking license to be issued by the Reserve Bank of India. If a company want to do a banking business means, then it should get the license so issued by the Reserve Bank of India. Banking companies to have the name where the banking and shall feature so that public in general know it is bank. So every banking company must include the word banking in its name in order to know that it is a banking company. Insurance company, a company registered under the Insurance Act and engaged in the insurance business as stipulated under the Insurance Act. So if a company want to work as an insurance company means it should engage with the provisions given by the Insurance Act. No company can commence insurance business without having the license to be issued by the Insurance Regulatory Development Authority (IRDA). So if a company want to function as an insurance company, it has to take the license given by IRDA. Insurance companies to have a name where the insurance word shall be the future so that the public in general to know the bank. So if for a banking company, the word banking must be involved. In the same way, for an insurance company, the word insurance should be involved in its name. Details are available elsewhere in this study material. Okay. So up to here, so the video length is going very much high. So whatever the rest of the topics are held, so will be given in the next lecture. So until then, if you understand everything, okay. If you're not understanding anything, means you can please comment below in this video. So if you like this video, please give a thumbs up. And if any of your friends are preparing for this CMA exams, please share this video link to them, and also subscribe to this channel for my next video update. Thank you. Bye.